recording has started.
Good evening. We are in this session to look into legal writing and drafting. We are trying to look at the various drafting documents. We propose to start with a bill. Then we shall also look at legislative proposals. We shall also look at other deeds that are executed. We have the deed poll and various affidavits. So we shall go in that order. So we will begin with drafting a bill. We decided to do a refresher course. The general principles of legislative drafting. The role of legislation is to stipulate the rights and obligations of citizens. It lays down powers, privileges, and duties of different persons in a given society. It states what can and cannot be done. The rule of law promotes good governance and stipulates development. For without law, there is chaos. General principles of legislative drafting. Legislation is codified law and should be drafted in accordance with the following general principles. 1. Legislation should be drafted in a clear, simple, and precise language. Being clear determines the ease of understanding and removes ambiguity. Simplicity requires that unnecessary elements are executed but should not result in legislation failing to have its intended effect. Precision ensures there is certainty in the mind of the reader. Legislation should take into account the end use of the law, that is, to whom the law is to apply, and the person responsible for implementing the law. For this refresher course, I wish to go on. So I will be highlighting the key points, and then we can always refer to this document we have shared in the group. That is, act should be concise and content should be as uniform as possible. A good legislative style should express key ideas succinctly. The language of an act should be consistent. A legislative sentence should be simple. A section should preferably contain a single provision. Long sentences should be avoided. A single sentence may be split into paragraphs that follow the progression of the reasoning. A compact block of text strains the eye and constrains the mind. The terminology used in particular law should be consistent with that law and with other laws, especially in the same field. Legislation should use gender-neutral language. When legislation is expressed in different official languages, the linguistics versions should be identical in structure and substantive meaning. We have Article 70 of the Constitution recognizing that there are two official languages, that is Kiswahili and English, in which legislation can be expressed in. Each version of the legislative text should convey the same meaning as in the other version. The structure of the legislative text should be the same in each language. In drafting legislation, there should be good organization of ideas to ensure proper organization of ideas within the text of the legislation. Each idea should be arranged in logical order. The general provisions should be followed by specific provisions and exceptions. Provisions that relate to the same subject should be grouped together. Provisions should be arranged in chronological sequence. Provisions that are significant should precede provisions of lesser importance. The act should be divided into groups of sections under headings, and sections should be numbered. Then chapter 2 of this document, we have the role of the council in legislative drafting. We'll just go very fast on this. The role of the council is to advise on the legislative mandate of the National Assembly. The council is therefore expected to work in close collaboration with the instructing clients and ensure that legislation is based on sound legal principles, give effects to the intended policy, and is clear and understandable. Additionally, council is the legislative drafting expert of the House. It's therefore imperative for council to take proper drafting instructions from the instructing client, who could be a committee or a member. The relationship between council and the client is governed by the advocate-client confidentiality. Council should provide advice and drafting services in a professional and impartial manner. Further, council should always give advice as to whether instructions are constitutional, consistent with the law, or compliant with existing policy. Council has a wider professional responsibility to ensure any legislation as finally passed by Parliament complies with the Constitution, is consistent with other laws of Kenya, can be implemented and is effective, is clear and unambiguous, and will withstand challenge in court to advise criticism by the wider public. The qualities of counsel should be competent. So counsel should have a minimum education qualification of a bachelor's degree in law. So you see, for persons working in these fields, persons working under the legal officer of the Kenyan Parliament or legal officers of parastatals, legal officers of non-governmental bodies. So, for example, you can have these independent bodies, like, so for example, if you are employed with the National Legal Aid Service, you see, they do not expressly require that it's a must that you have a practicing certificate or the advocates training program certificate. A bachelor's degree in law is a competent qualification. Attention to detail and a clear systematic approach to problems. So I want us to move very fast to the technicalities of drafting and the grammar itself. There's a grammar in this document. That's what I'm rushing towards. The responsibilities of counsel: receiving and reviewing instructions from the client, alerting the client on any issues that arise out of instructions or seeking clarification of matters, drafting a bill that is clear in order to give effect to the policy intent, devising solutions to problems that arise during the drafting process for discussing with the client, ensuring the assent copies of laws passed by Parliament are completely accurate, drafting committee stage amendments for individual members of committees, scrutinizing delegated legislation to ensure conformity with the Constitution and relevant laws. We have ethical duties in legislative drafting. The following duties are placed upon the council. Duty to be competent, we've just assessed. So every council has duty to the client to be competent. The clients of the drafting office of the National Assembly include the office of the Speaker, Clerk, Leader of Majority Party, Leader of Minority Party, committees, members of the National Assembly. Council owes the client a duty to be competent enough to undertake drafting on client's behalf. As a member of the legal profession, a counsel is held out as a knowledgeable, skilled, and capable in practice of law. Accordingly, the client is entitled to assume that the counsel has the ability and capacity to deal adequately with all legal matters. Duty to be loyal to the client. So, counsel serving the National Assembly have a duty to refrain from public criticism of Parliament or government. Duty to be confidential. In the course of receiving instructions, counsel is privy to sensitive and confidential information. These may include advanced knowledge of budget measures, of personal opinions of members of Parliament and cabinet secretaries on controversial subjects, and of proposed plans to deal with public issues. This is one aspect of council's work and makes the job interesting and rewarding. However, privilege also imposes a duty on the council to hold information in confidence. The ability to hold information in confidence is essential, developing trust between council and the Parliamentary Service Commission as the employer. The duty to maintain confidentiality exists not only when the council is employed, but also after council has retired or resigned. These are also the teachings. This last sentence is also as per the teachings of professional ethics, particularly SOPEC. Duty to be a good servant and not a master. Council has a duty to provide clients with service that is competent, timely, conscientious, diligent, efficient, and civil. Council aids, supports, advice, and carries out, but does not lead or direct. As a good servant, the council will only succeed only if those who instruct and employ him or her succeed. Council must adopt or maintain a servant's attitude while dealing with instructing clients. So be a good servant, not a master. You should be prompt. Should ensure you have full reporting, honesty, integrity, courtesy, and respect. Duty to be a good counselor. So, as Lord Dring once commented, the sum of the matter is this: that to prepare a good bill that draftsman must receive sufficient instructions, but they will necessarily be short, and he must exercise a large discretion in filling the gaps. So we have chapter 3 of this pager on the reference documents. The first one is the Constitution of Kenya. Council is the fundamental law. Council must ensure that each law drafted complies with the Constitution. Some of the key references provisions on legislative drafting is anchored include Article 1, sovereignty of the people, 2, 4, 5, and 6, supremacy of the Constitution, 10, national values and principles of governance, 94, role of parliament, 95, role of national assembly, 109, exercise of legislative powers, 110, bills concerning county governments, 112, originating ordinary bills concerning county governments, 114, money bills, 115, presidential assent and referral, 116, coming into force of laws, and 4th schedule to the Constitution. Interpretations in General Provisions Act Cap 2. Interpretation and General Provisions Act provides the basic rules about courts should interpret legislative provisions. It defines certain words and expressions and removes the necessity to repeat the definition in an act. Statutory Instruments Act 2013 Act provides a comprehensive regime for making, scrutiny, publication, and operation of statutory instruments, establishing mechanisms for parliamentary scrutiny of statutory instruments. Revision of Laws Act. The Act makes provision for contents of and for provision of laws of Kenya. National Assembly Standing Orders. The Standing Orders provide the rules of procedure that guide proceedings of the House. They act as a guide to Council how a legislative proposal bill is processed in the National Assembly. Additionally, on some occasions, Council may be required to refer to Senate Standing Orders. International instruments and conventions, Black Laws Dictionary. Then we move on to chapter 4, the drafting process. So let's see. The procedure for drafting bills is set out in Standing Orders 114, Introduction of Bills, 115, Printing of Amending Provisions, 116, Enacting Formula, 117, Memorandum of Objects and Reasons, 118, Provisions and Delegated Powers, 119, Limitation of Fundamental Rights and Freedoms, and 120, Publication of the National Assembly Standing Orders. So the procedure for drafting bills is actually set out in the National Assembly Standing Orders. Standing Order 114 all through to Standing Order 120. The legislative proposal is introduced into the National Assembly by a member or a committee of the National Assembly in the form of a letter or a draft bill to the Speaker of the National Assembly. The legislative proposal is accompanied by a memorandum of objects and reasons. So we shall see this legislative proposal, and then we shall also see a memorandum of objects and reasons. How it looks like. All these, the legislative proposal shall look at some notes. These samples of memorandum of objects and reasons, these are in, there are some samples in the Parliament website. The memorandum contains a statement of objects and reasons of the bill, delegation of legislative powers and limitation of fundamental rights and freedoms, if any, whether the bill concerns county governments and financial implications, and if the expenditure of public monies will be involved should the bill be enacted, an estimate where possible of such expenditure. A memorandum should generally indicate the objectives of the bill. Upon receiving instructions from a member, the Speaker of the National Assembly refers the legislative proposal to the Clerk of the National Assembly. The Clerk then refers the legislative proposal to the Directorate of Legal Services for review and drafting. You receive instructions and drafting. Now the legislative proposal is assigned to Council. So now we are in the Directorate of Legal Services. So this Council we are referring to is the Directorate of Legal Services at the National Assembly, who is expected to confirm receipt of instructions to the member and invite the member for consultation. The drafting instructions should set out. Sufficient background information to enable Council to appreciate the facts and problems of the bill is intended to deal with. The objectives of the bill with accurate information on the necessary details, including those of a technical nature. Any consultations which have taken place on the proposed legislation and the advice given at the consultations, references to any relevant court decisions on the matters at issue, references to the reports of any commission or other body that has considered the matter, the administrative provisions needed to implement the bill and the manner in which the bill is to be enforced, the extent to which existing laws may have to be amended or repealed, whether transitional provisions may be needed to deal with matters which have arisen before the bill comes into operations, the procedure and manner of appeals against an executive decision where a matter of policy, those appeals are considered desirable, and any special provisions on commencement of the bill. After examining instructions, Council may raise any of the following matters of legal significance. There is the question of retroactive legislation, retrospective legislation, extraterritorial effect of any given to a bill, whether the bill is to bind the state, saving provisions for persons already engaged in trade or a profession which is to be regulated by legislation for the first time, special provisions which concern evidence and honors of proof. Then Council should study relevant laws, including amendments and subsidiary legislations, and be aware of case law which may have a bearing on the subject matter. Legislations from other jurisdictions may also be useful for reference. Council then translates the instructions into a draft bill and forwards it to the member for approval and signature. Money bill certification, Council seeks advice from the Parliamentary Budget Office on whether the bill is a money bill or not. So this is very key, money bill certification. That is contrary now to the general assumption that a money bill, you just assume it's a money bill if it's concerning county governments or whether it is providing for a certain expenditure. But now, all the same, the way to ensure that it is a money bill, or the way to know if it is a money bill, is certification from the Parliamentary Budget Office. Speaker's approval for the pre-publication scrutiny. On receipt of advice from the Parliamentary Budget Office, Council submits to the Speaker the draft bill with comments on whether it's a money bill, it conforms with the Constitution and the law, it affects county government. If it is a money bill, the Speaker refers it to the Budgets and Appropriations Committee of the National Assembly. The publication scrutiny of bills by a departmental committee, Standing Order 114.3b of the National Assembly Standing Orders requires that all legislative proposals which are not sponsored by a committee be referred to the relevant committee for publication, scrutiny and comments. The committee is required to submit its comments on the legislative proposal to the Speaker within 14 days of the receipt of the legislative proposal. The pre-publication scrutiny process is intended to provide a win-win mechanism for the House to test the acceptability of the legislative proposal by the members prior to the publication to save time of the House from frivolous legislative proposals. During pre-publication scrutiny of bills, the committee interrogates the policy behind the legislative proposal and the appropriateness of the legislative measures proposed in it. After pre-publication, a scrutiny committee may recommend to the Speaker that the legislative proposal A, be published in its original form, be published with amendments, then C, not be published. Considerations by the Budget and Appropriations Committee. This is where now it was a money bill. Article 114.2 of the Constitution requires that if it's in the opinion of the Speaker, a motion makes provision for a matter listed in the definition of money bill, the National Assembly may proceed in accordance with the recommendation of the relevant committee after taking into account the views of the Cabinet Secretary for Finance. The Standing Order 114.3a further provides that where the Speaker is of the opinion that the legislative proposal is a draft money bill in terms of Article 114 of the Constitution, the Speaker shall direct the legislative proposal to be referred to the Budget and Appropriations Committee and shall be proceeded with in accordance with the recommendations of the committee, having taken into account the views of the Cabinet Secretary for Finance and examining the manner in which the legislative proposal affects the current and future budgets. Publication, where committee recommends that the legislative proposal should be published subject to certain amendments, Council should ensure that the committee amendments are specific and implementable. Upon receipt of the recommendations or comments of this committee, the Speaker may accept or reject them based on the advice of Council. When the Speaker accepts the recommendations of the committee, the Speaker then approves the legislative proposal for publication. The legislative scheme and the form of the bill. After drafting instructions have been fully understood, the next step is to develop the legislative scheme, which is the plan for the bill. Council drafts the provisions of the law in logical sequence. This may be done by listing the marginal notes, which may reveal the gaps in the instructions. Very key. So we are developing the legislative scheme, the plan for the bill. The broad framework of a bill is as follows: preliminary provisions, which are the long title, preamble where justifiable, enacting formula, short title, commencement date, interpretation provisions and application, principal provisions, which are substantive provisions and administrative provisions, miscellaneous and supplementary provisions, which include offences, search, seizure, and arrest, provisions on delegated powers and Article 94(6) of the Constitution as read with Standing Order 118 of the National Assembly Standing Orders, final provisions, which are the savings, transitional provisions, repeals, consequential amendments, and schedules. Arrangement of clauses sections. The arrangement of clauses is on a separate page immediately before the substantive provisions of the bill. The wording is the same as that used for marginal notes in the bill and serves as a useful index to the bill. It is part of the bill but not the subject of debate in Parliament. After enactment, it becomes arrangement of sections. A further check is needed to ensure that the arrangement of sections is an accurate reflection of the Act in its final form, and that account has been taken of any amendments which have been made in the course of enactment. The other thing is you arrange it into parts. A bill may be divided into parts. A part contains one or more provisions dealing with a distinct subject matter. Council may divide the bill into parts by taking into consideration length and complexity of the bill. Preliminary provisions, a marginal note. Each clause is given a marginal note which provides a guide to the contents of the clause. A marginal note must be short and accurate. Council should avoid replicating the entire content of the clause in the marginal note. Victor, I remember
Yes.
and we questioned how do you apply the marginal notes, and this is where it applies. So you should ensure that the marginal note is short and accurate. Should avoid replicating the entire content of the clause. And again, the marginal note is kept in the bill so that when the act is assented into law, that final document does not have marginal notes. The choice of an
Good observation.
Yes, the choice of an appropriate marginal notes becomes difficult when a clause is overloaded. Council should spread the contents of an overloaded clause into two or more clauses, which can then be given the appropriate marginal note. Long title. The long title is found at the beginning of the bill. It sets out the general purpose and the intention of the legislation. It is a useful aid to ascertain the scope of the bill and should be wide enough to provide a general overview of the contents of the bill. A long title concludes with general words for connected purposes. So we have an example of a long title here. It is important to note that the words for connected purposes may also be used in the long title of amendment bills if necessary. A preamble is an aid to construction that explains the reasons for the enactment of the bill. It is seldom used in the National Assembly. A preamble may be appropriate for a bill dealing with constitutional matters or the domestication of international conventions. So that's where you apply a preamble. Matters of constitution or domestication of international conventions. Seldom used in the National Assembly. A good thing here, we have an example of a preamble. This is the preamble for the Constitution of Kenya 2010 with the people of Kenya. acknowledging, honoring, we are proud, we are respectful, and we are committed, recognizing, exercising. Then we adopt, enact, and give this constitution to ourselves and to our future generations. God bless Kenya. The enacting formula, this expresses the appropriate state authority and confirms the legitimacy of an act. The enacting formula is provided for in Standing Order 116 as follows, enacted by the Parliament of Kenya as follows. That's the enacting formula. The short title, these are means of identifying and citing an act. It should be informative and brief. The year of enactment is added to the short title, where the scope of legislation is restricted to a sector. A general topic may be followed by a reference to the particular topic in brackets. We have the commencement date. Commencement date is the day the act comes into force and is to be distinguished from the date of passage of a bill by Parliament. The date of entry into force is provided for under Article 116 of the Constitution, which provides that a bill comes into force on the 14th day after its publication, unless the Act stipulates a different date at which it will come into force. So, Article 116 provides that it comes into force on the 14th day after its publication, unless the Act stipulates otherwise. In light of the provisions of Article 116 of the Constitution, Council should advise committees not to confer power to executive to determine the commencement date of an Act of Parliament. Further, Council should draw the attention of the committee to provisions of Article 116(3) of the Constitution, which provides that an Act of Parliament that confers a direct pecuniary interest of the members of Parliament shall not come into force until after the next general election of members of Parliament. A good caveat in the Constitution. It's a good check. Interpretation. An act often contains an interpretation section which sets out definitions of various words and expressions used on more than one occasion in the act. This section assists in conveying to the reader the intended purpose of the legislation in a simple, unambiguous, and a consistent manner, and also to avoid needless repetition. The section is placed at the beginning of the act, immediately after short title, to inform the reader if any words are to be given special meaning. The definition is intended only to affect one part or one section. It should be placed in that part or section. Council will find it better to leave the detailed drafting of this section until the draft bill has been completed, making a note of any words and expressions which can be used, including in the interpretation section as the drafting progresses. Any definition of a term should conform to Article 260 of the Constitution and consider applicable definitions in Interpretations and General Provisions Act. Application. This provision gives an indication of the application of the Act in order to remove uncertainties and may be used in the following circumstances. A. Where the Act is to extend circumstances arising before or pending at the date of commencement, for example, in matters relating to taxations or pensions. The geographical area where only part of the country is to be affected. The particular class of persons or things to be affected, where the Act or part of it is to be given extraterritorial effect, and where the Act is to bind the state. Section 75 of the Interpretation and General Provisions Act provides that no written law shall affect the rights of the government unless it is expressly provided or unless it appears by necessary implication that the government is bound. If the Act is to bind the government, the Council should state expressly that the Act binds the government. For instance, Section 76 of the Interpretation and General Provisions Act provides that the Act binds the government. Principal provisions. We have substantive provisions, clauses which set out basic objectives and main principles of the bill. We have administrative provisions. Sections provide for administrative mechanisms for implementation of the Act, including establishment of statutory bodies such as boards, councils, and institutes. Miscellaneous provisions covers matters arising out of the main object of the Act. includes offences and penalties, provisions on delegated powers, sets out purpose and objectives for which power to make subsidiary legislation is conferred upon any state organ, savings, transitional provisions and repeals. Savings and transitional provisions are dealt with together. These matters become relevant when the law is changed, either by the enactment of a new act or by the repeal or amendment of an existing act. Transitional provisions are inserted in order to apply the provisions of a new act to situations already in existence where the act comes into operation. We have the schedules. A schedule is used in expounding matters provided for in substantive provisions of a bill. It may be used for repeal of several acts, a number of amendments, transitional provisions if they are long or complicated, constitutive or procedural matters in relation to a statutory corporation, the text of an international convention or agreement, rates of taxes, duties or other charges, arithmetic or scientific formulae, forms or so when you say forms, remember probate administration rules has forms. We have a number. Companies Act regulations, they have forms and such. We have so many. So you'll just go and check the various subsidiary legislations and see where the forms are in the schedule. A model agreement to be followed by persons who want the agreement to be legally valid. And you know now the forms are usually they are usually kept there but pursuant to a rule in the same act, in the same regulation or a section of a particular act. Now we get to the grammar. The legislative sentence is the means council uses to translate policy into law. In each sentence, there must be A. The legal subject, the person to whom the law is to apply. B. The legal action, the law which is to apply. And C. The circumstances in which the law is to apply. You have to have a legal subject, you have to have a legal action, and you have to have the circumstances in which the law is to apply. The legal sentence is an arrangement of words to express a command or state a prohibition. It states how, the manner in which the law is to operate, what, the nature of the legal action, when, the conditions under which the law is to operate, where, the circumstances in which the law will operate, who, the legal subject, the person given the responsibility, on whom is placed an obligation or prohibition, why, the policy considerations of the law. So you have your 5 wives and 1 husband in the legal sentence. Council is advised to take care not to make legislative instruments which do not either command or prohibit certain actions. These kinds of instruments include guidelines and manuals. Council should use short familiar words and phrases, short sentences which state only one thing, use the same word to express one meaning, consistent spelling, the standard form of language of the drafting office. So members, we're in the grammar now. We're still in the grammar. Council should not use archaic words such as herein, hereto, heretofore, before mentioned, aforementioned, above referenced, ambiguous words, legal jargon, Latin expressions, more words than necessary. Tense. Laws are meant to be of continuing application and should be written in the present tense. This avoids complicated and awkward verb forms. The active voice should be used instead of passive. Do not write. The function of the commission will be, or will include, or shall include. Write. The function of the commission is or includes. Do not write. A contravention of a provision of this act shall be an offense. You should write. A person who contravenes Section 5 of this act commits an offense and shall be liable on conviction to a fine not exceeding 500,000 shillings or to imprisonment for a term not exceeding 6 months or to both. The use of active voice names the legal subject in the sentence before completion. It says who does the action described by the verb. A sentence in the passive voice may not include a legal subject to be complete. Use of the passive voice should be avoided because a sentence in the passive voice does not assign responsibility clearly. The passive voice places the receiver of the action before the main person, and passive construction may lead to ambiguity when used in legislation. Exceptions where passive voice may be used are. So there are exceptions. When the person to carry out the act is unknown, unimportant, or obvious. Example, the price of petroleum may be fixed. The letters have been dispatched. To put old or repealed information at the beginning of a sentence and new information at the end of a sentence to stand out. Example, the indictment, information or charge sheet must charge the person with committing a crime. To avoid the use of gender-specific language, shall. Council shall use shall to impose a duty or an obligation. Example, any person driving a motor vehicle on a road shall carry his driving license or provisional license, and on being so required by a police officer, produce it for examination. Council should avoid the use of shall to confer a right. Do not write, you shall receive. Right? You are entitled to. Council shall not use shall to state a rule of law or how it applies. This creates a false imperative. For example, do not write, a person shall be eligible to apply for. Right, a person is eligible to apply for. Do not write, a person who commits an offense shall be liable. You write, person who commits an offense is liable. Do not write, it shall be unlawful. You write, it is unlawful. Council shall avoid the use of shall in drafting definitions. Example, do not write, livestock shall mean cattle, herds, flocks. Right? Livestock means cattle, herds, flocks. May. The word may indicates discretion to act. The council should use may to express a power or privilege. It should only be used to enable a person to do something freely. Do not write, it shall be lawfully for the commissioner to. This creates a false imperative. Right, the commissioner may. And or. And is used construed. And is usually construed conjunctively and connotes togetherness, while or is construed disjunctively and suggests a choice between two or more options. So, for example, when you're listing a number of conditions, so if they're conjunctive and should be used together, read together, then that means that you use and, which is to say that all these options that you have, they rank they rank together. But when you use or, it is disjunctive and it suggests that it is either of the options that are provided in the conditions. Council should use and to connect two or more phrases, conditions, or events, all of which must occur, while or should be used to connect two or more phrases, events, conditions, when only one or more, but not all, need occur. Never use and or, rather use A or B or both. Example, the register includes each person who is 70 years or older, each person who is permanently physically disabled, and each person who has been declared mentally incompetent. Or, the register includes each person who is 70 years or older, is permanently physically disabled, or has been declared mentally incompetent. You see? So you have to check. And is conjunctive or is disjunctive. You have article are, an, and the. Are is used as an indefinite article in legislative drafting to denote the singular, often as part of a general statement. An is used before a vowel. The is used as the definite article. It is placed before a noun. Example, a citizen shall possess an identity card. Any means one of some. It is often misused in legislative sentence when one person or thing is being referred to. It should be often replaced by a or an for clarity. Each and every. Each refers to two or more in a numerical context where there has been previous identification. Example, there are 10 attorneys in the division. Each is a lawyer of 10 years standing. Every implies a class. Example, every attorney is a lawyer. The reference in this example is to each attorney of an unidentified class of lawyers in the Attorney General's department. The reference here is to the number. As there are seldom references to number in legislation, it is generally better to use each instead of every. You have all. The word all is a spurious form of emphasis and generally should not be used. The word may, however, be appropriate where the intention is to refer to all the numbers of a group collectively. Such and say. Such is misused in legislation and creates ambiguity. It should be substituted with the words there, and, there are, or that. Same is used as a substitute for a preceding noun or phrase in legal jargon and does not add to legislative sentence. It should not be used as it creates ambiguity. The word it or them can be used as a substitute. Example, do not write. It is necessary for the applicant to file such. You write. It is necessary for the applicant to file them. Where? The use of the word where conveys a description of a factual situation. Example, where a person has committed an offense. When? It is used in legislative drafting to indicate a single rare concurrence of a contemplated event. Example, when a person is absent from a Boston institution in persons of a license or is under supervision in persons of Section 29 of this Act, no person whatever shall interfere with the control or supervision conferred in respect of the absent person by the license or by the said section, as the case may be. Boston Institutions Act, Section 44, 92. If the council may use if to state a condition in legislative sentence. Example, Section 65 of the Access to Information Act, number 31 of 2016. A public entity is not obliged to supply information to a requester if that information is reasonably accessible by other means. Which and that. Which is non-restrictive, while that is restrictive. If the insertion of a comma in the phrase does not change the meaning, council should use which. Where the meaning changes due to the insertion of a comma, council should use that. An unrestricted clause is one which can be omitted or placed between brackets without destroying the meaning and is generally set off by commas. Example of use of that. No person shall employ a child of compulsory school age in any labor or occupation that prevents such child from attending school. The Basic Education Act, number 14 of 2023, section 38. Example use of which. No advocate shall, in connection with his practice and as an advocate, without the written permission of the council of the society, which may be given for such period and subject to such conditions as the council thinks fit, employ or remunerate any person to his knowledge who to his knowledge is disqualified from practicing as an advocate by reason of the fact that his name has been struck off the roll, otherwise than at his own request, or is suspended from practicing as an advocate. That is section 41 of the Advocates Act, cap 16. Deem. The council should only use deeming clause to create a legal fiction. A deeming clause can be used to provide for the retroactive operation of an act. So, example, this act is deemed to have come in force on the first day of January 2000. So, deeming is a legal fiction, for example, for retroactive application. Then we have to, under the Cancer Prevention and Control Act, Cap 246B, for the period prior to the announcement of the results of the first elections of Parliament as contemplated by Section 2 of the 6th Schedule to the Constitution. Reference to a Cabinet Secretary in this act shall be deemed to be reference to a Cabinet Minister, and reference to a Principal Secretary shall be deemed to reference to a Permanent Secretary. In order to avoid a legalism, Council should use consider instead of deem in situations where a legal fiction is not being created. Then we have before and after. Before and after exclude a specified day. Council should avoid using from because it is equivocal. Example, after March 13, after 13 March excludes March 13. From 13 March is debatable, though 13 March is probably excluded. Council should use phrase on and after date when the specific date is to be included. Between and. The two terms between and should be used with caution in legislative sentence in reference to dates. Example, do not write between 1st January and 1st March. Write after 1st January and before 1st March. By, until, till. Where action is to be taken by a stated date or until or till a date, it is better to say not later than or before. Verbs associated with particular nouns. While drafting legislative sentences that confer obligations, Council should note to use certain verbs with nouns uniformly. Council should use these formulations for the following standard phrases: to discharge a duty, to perform a function, or to exercise a power. Chapter 7, we have the rules of drafting. Victor, any advice? Do we continue?
Maybe you can skim down once we see whether there is something of a technical nature, like the way you are.
Just punctuations and such. Punctuations, now these are the practice notes, so they are in the manner of the grammatical structures of a bill. The good thing is this document is with the members. I urge members to see the document. So what we have been skipping here is matters punctuation. Then we have, so we're still in chapter 7. I want to see chapter 8. Yes, we have chapter 8. Chapter 8 is only on definitions and the purposes of having definitions in a bill. How do you make the definitions? How do you make the interpretations? Then let's see chapter 9. So that now we drop down to a bill, and we will be able to underline what we have just captured. The screen has just gone blank. A minute. So basically, we have now chapter 10, drafting financial legislations and provisions. So Victor, I find we can proceed Then we have issues to refer to, then we always refer to this page. So we can go ahead and the bill. And now that we have
Okay, so yes,